Welcome to the Yunusov Question. I am Pulat Yunusov, your host. I interview lawyers and judges. This show is supported by my law practice, Yunusov Law Professional Corporation. I am a commercial litigator. I've done nothing but litigation since 2011. Many of you know me or my work. I would really appreciate your referrals. They are safe with me. Thank you and enjoy the show. Hello, everyone. Welcome to another special judicial episode of the Yunusov Question. My guest today is Honorable Justice Andrea Himel, Superior Court of Justice of Ontario. Hello, Justice Himel.
Oh, hello. Thank you for having me. As I mentioned in some emails we had recently, I spent most of Christmas break in my downtime listening to various episodes, and I have learned so much about my colleagues and about lawyers in the profession. So thank you.
This is great to hear. Thank you for this feedback. You know, I always start with the person's origins. Sometimes it feels like we need to show lawyers and members of the public that judges are humans, that they're not machines. And we will talk about some of your writing, some of the essays that you created for continuing professional development. And I really liked the metaphor, the negative metaphor in one of them, when you said that the court is not a counter at McDonald's. You can't just come there, make an order, and expect that order to be served. So, and in similar vein, judges are not machines, they're not automatons, they're humans, and here we are trying to prove that to everyone. Well, let's start with the basic proof. Where were you born?
Born and raised in Toronto. Went to McGill. Okay. Did my joint law social work degree at U of T. So born and bred in Toronto.
Okay. And here's a question that I think will be on a lot of lawyers' mind. Are you related in any way to Justice Susan Himel of Toronto?
So I am. She is my father's second cousin. And it's a pleasure when I run into her to see her. I met her actually a lifetime ago when I did my placement at the Children's Lawyer as part of my social work degree. She came down, I think she might have been with the Public Guardian at that point, and we had coffee, which was really nice.
She is amazing. I had the honor of appearing at her before years ago, and it's really great. Maybe she will come to my show one day. That would be really fantastic to interview her as well. I really like making connections between my guests and other guests of the show. So, for example, you are in Newmarket. You are with the Superior Court of Justice in Newmarket. A past guest of the show, Justice Susan Fraser, is there. So that's another connection. I know that you went to McGill. You went to McGill for your undergrad. You know who was at McGill at about the same time, and it's probably not who you're thinking. Another guest of the show, Julie Hennigsberg, President and CEO of Kids Rehabilitation Hospital, Holland Bloorview, here in Toronto. She was in law school, 87 to 91. And I think you were an undergrad around the same time. So I don't know if you guys, it's unlikely that law students will cross paths with undergrads, but I thought I'd make that connection. And of course, I think you were in the undergrad together with Andrew Bernstein, also a guest of the show in the past, a litigator here in Toronto. So small world. You are in Newmarket. It's the family division or family branch, as they say. Can you please talk about the family branch? You are a Superior Court judge. We know about the division of our Superior Court into regional interregional categories. Tell us more about this division into the jobs to be done categories. Why divisional? Why family? Is it a separate court? What is the basis for that? Can you talk a little bit about that?
Sure. I mean, there was a pilot project many years ago, sometime in the 90s, I think, with this idea that we should be trying to serve families in one place. And about 2018, they did their last or their most recent addition to the UFC court, and I think it's about 50% of the population now gets served by a unified court. I sit with my generalist colleagues, and when they have time, they help us out with some family work. But most of the family work done in York Region are done by the 6 full-time and 1 supernumerary judge. So we do everything. We do everything from the child protection to the adoption to the family responsibility office to regular what we call domestic cases. We do it all. If you litigate in Toronto, then if you have a property claim or a divorce, you have to do that at 361 University. If you only have child-related issues or you have child protection issues, you can deal with those at either 361, well, not child protection, that's only at the OCJ, which is on Jarvis in North York, but you can deal with your other issues at either of those courts. So the idea was, why have 2 places doing 2 different things when we can do it all in one place? And that's what you do.
So you do nothing but family law, correct?
That's it, day in and day out.
Yes. You mentioned your generalist colleagues that sometimes step in to help you out. Are you talking about those rotations that other judges mentioned on the show when a generalist judge will circulate through the family rotation, the criminal rotation?
No, so outside of Toronto and perhaps Ottawa, I don't think there are any of those distinct rotations. So at the balance of the superior courts across Ontario, if there's a unified family court, you might get what's called a family patent. That's what I have. Or you get a generalist patent where most of your work will be some combination of civil and criminal, and you might be doing some family depending on the location and how things go.
You have a joint degree from UFC. You have a joint LLB and MSW degree. So MSW is, of course, Master of Social Work. Why did you want to or choose to do the joint degree? Why social work? And how is it working out for you right now? Is it helpful? What is the story there?
So I always wanted to be a family court judge, and I was only ever interested in where law and social work connect. So when I thought about law school, it was always with this idea of doing it with social work. So U of T has a very small, but really a terrific program where you do both degrees in a 4-year program. So a year of social work, a year of law, and then 2 years combined. So it gave me the chance to do a placement in my social work year at the Children's Aid Society of Toronto, and then in my combined year to do it at the Children's Lawyer, where I worked as what's now known as a clinical investigator. And I did some policy work on solicitor-client privilege. It's really about the merging of the two. The culmination of that degree was a thesis that I wrote that was published in the Canadian Family Law Quarterly about parental abduction, which I reread recently, and sort of interesting to see what I was thinking 20 some odd years ago. So anyway, how did it fare today? I think it fared me pretty well. I've been very lucky. I really have been able to look at where social work and law merge throughout my career. I articled at Bay Street at a firm called Smith Lyons, but they happened to, while I was there as a summer student, be retained to act on a criminal case defending a social worker accused of the death of a baby on her caseload. And I spent a good chunk of my articling year, defending her in this preliminary inquiry. So, I jumped from there to a firm called Tork and Mains, where I practiced family law. And as you can imagine, family law really is the culmination of social work law. And, today, I certainly use my mediation skills, and I think I have some credibility because I come at looking things both as a social work perspective and law.
You sent me a great article that you wrote I assume for family lawyers. It's called Mission Possible: Responses to Difficult Client Positions. And I want to spend a lot of our time today talking about this article, doing a deep dive and talking about each element of this piece. You say in the article that these are the tips for professionals to help clients move from unreasonable to reasonable positions. And then you say the key is to employ child-focused and family-focused creative solutions. So in these 2 sentences, I think there are great depth to explore. And the first level of depth is the suggestion that family lawyers manage their clients more, perhaps, than other lawyers. This is really interesting to me as a commercial litigator. My clients are often extremely sophisticated corporate or professional parties. So I try to manage them, but oftentimes they end up managing me. So I really want to hear more about this distinction that makes family law unique, and that make it more incumbent on family lawyers to manage their clients. Can you talk about that a little bit?
Sure. I mean, I think we have to start with step one, right? Which is what is your, who's your client and what's your obligation? I mean, obviously your client is the person you're helping, or if you're a mediator, the people you're helping. But I don't think you can answer that question without reflecting on the children, if there's children in the family. Because the reality is, I think you have an obligation to be considering their needs and their interests as you work with your client. I think that it's not a traditional, you just take your instructions from your client and those are your positions. I think that family lawyers, first and foremost, also have to figure out what kind of lawyer they want to be. Do they want to be, client-driven, rights-driven, more facilitative? And that also will affect the kind of practice people choose. But the bottom line is this, people are at very, very significant emotional places when they come to see you, very much. We talk after people are grieving, right, about the 7 stages of grieving, right? There's anger, there's, all those 7. Those all are part of what happens when people separate too. And the two clients, you acting for one and the person acting for the other, right? The clients are at different places. So again, you have to understand where your client's at and really be giving them some advice. And in terms of managing them, you have to figure out what you feel comfortable with, because it's not just about mimicking out what they say. If you don't feel comfortable with the instructions they're giving, once you give them the advice about what's sort of reasonable and what's sort of child focused, I think you have to decide if you want to be the client lawyer who does that or just says, not me, thank you. So I do think there's a huge element of client management. Because of where the clients are at, there's often an element of really almost being a social worker, or the risk of being a social worker to your clients. And there's always going to be some element of that, but really you cannot do that for your client. You have to help them find the right person to support them, because your job is to explain the law, give advice, and hopefully with them work on a plan. And I'm all about roadmaps, right? All about roadmaps. So when you're meeting with your client, and it's a family law client, from day one, what's the end goal? What's the range of where we can go from here? It's a teamwork effort. So I do think it's different than a traditional solicitor-client role. And I think the court system in family law is changing as well, right? We don't have, for many years, we haven't had a strict, we go from motion to motion, motion to trial. A lot of the court work we do is about trying to get people to settle, because clients who have control over the outcome of their cases tend to make more lasting agreements that are, have better rates of compliance and are more child focused.
You just mentioned that family lawyers are different from solicitors, and it makes me think that they're different from commercial litigators. They're different from many other types of lawyers. After meeting a lot of criminal lawyers, especially after interviewing some superior criminal lawyers for the show, I'm convinced that criminal law is a calling. Do you think family law is a calling? I'm not sure that commercial litigation is a calling, but is family law a calling?
I think that's actually a really great way to express it, for sure, right? I mean, yes. 100%. You have to put up with a lot of conflict. If you're going to litigate, you have to be ready to be on your feet. You also have to, like I said, manage all those ethical duties that you internally might deal with, and the ones dealing with between you and your client. And frankly, most family lawyers don't make anywhere as much money as most non-family lawyers. A lot of family lawyers rely on legal aid. Legal aid has been constrained, especially in the last few years. So it's difficult to manage. You have a lot of sole practitioners. A lot of family lawyers who don't have a lot of good mentoring, which is really unfortunate. A lot of family lawyers working out of their homes to save on money without assistance, right? So it's really, and you have very needy clients who don't understand the boundaries of 9 to 5 and expect to be responded to. So I think it's actually a really good way to say it. It is a calling, and it's not for everyone, which is why I think dabbling in family law is a very dangerous thing to do for your clients and for you from a law society point of view, right? there's a certain level of expertise. It's not, okay, well, the people who don't really want to practice family law, don't practice law, they should go practice family law. It's not like that. It actually is quite complicated. And the people who want to mediation is not actually easier than litigation. It's not like you can choose all these easy routes in family law. It's complicated, frankly. Especially as a judge now, right? A lot of our cases have corporate commercial elements to it. They have immigration elements to it. There's constructive trust. There's third parties, oppression remedies, right? So you might go in thinking you're going to just focus on, and maybe you choose to, right, on children and their child support and such. But if you have a broad-based family law practice, if you practice in Toronto, or you practice in the York region and a lot of other places, if you're open to it, you can have a very rewarding career involving a lot of different areas of the law, but you have to find that calling.
So the second level of depth that I wanted to raise as a precursor to diving into the actual article is children. You wrote that the key is to employ child-focused and family-focused creative solutions for advocates. Is there a huge difference between a family law case with children and a family law case without children?
Of course. The family law case with children, you are dealing with business partners, right? You are dealing with, they are forever business partners. It does not end at 18. It doesn't, right? And so they have got to figure out the conflict, and they have got to figure out how their long-term relationship's going to go when you as a lawyer are gone. So it's very different than parties who aren't parents, because they can have, and sometimes there might be ongoing spousal support where there's payments every month. Sometimes it'll be a monetary, almost like a business division of a business, right? You take this, you take that, have a good life, that's it. So it is very, very different for sure.
I see. But do people who marry today, do they even know that the law really sees them as business partners?
I don't know, actually. That's a good question. I mean, I have a lot of catchphrases, and I like to throw these out in my court.
Yeah, we want to hear them.
Oh, I have lots of them. And so the first one I'll start with is reality check. Right? I'll come in, I'll say, I've read their materials. I actually always start by asking them about their children, to describe their personalities, and then I talk about what they want for their children as they grow to be the adults they want them to be. What do they need from both the parents? And I have about 10 statements I put to them, and they always say yes to everything, because they're things like, want to have a positive relationship with the other parent, don't want to put them in the middle, these conflict, and that type of thing. So, and then I ask them what they want to add, and then they both agree with the other parent's statements, and I start there. Why do I start there? Because this is about the children, right? And then in many cases, I tell them that, today the conference is a reality check. We need to focus on where we go from here. I'm not spending the hour I have been allocated talking about the 10 years that got us here and all these things that he or she or they did to you. So where do we go from here? It's road mapping the future, because that's the way it goes, right? So I don't know if that answers your question, because I can't remember what your question is, but there you
go. It answers my question. So I just want to remind our audience that we are talking right now about helping clients, family law clients, move from unreasonable to reasonable positions. And I assume this is really a day-to-day of a family lawyer, because so often clients have unreasonable positions because of emotions, because of drama, and other related things, family, right?
So and because of social media, because of what their friends tell them is the right resolution, right, where they get in their family law advice, which is actually why family law should be taught as a required course for every lawyer, because every family has family law problems. Not so the lawyer can give their family and friends legal advice. Obviously, they shouldn't do that. But there's so much misinformation and out there that it's really important that everybody who practices law has a fundamental understanding of family law. I should add, obviously my comments today are my own perspective. I'm not speaking on behalf of the court. This is just my experience, not only as a family judge, right? I've only been a judge for a couple of years, but I was a mediator and a family lawyer for many years before that.
Right. What is the worst misinformation about family law that you've ever heard?
I can't answer that question, but I will answer this question. What is the most frequent error that people make?
Right.
And here it goes, right? That they should have a 50-50 schedule because that is what is right. That's the law, and that's what's fair. 50-50 of their children, 50-50. That is actually not the law in Ontario. And that's something that people would learn in law school. If they taught family law and people had to take it. So what is the law in Ontario? It is, there is no presumption of 50-50 parenting. There is no presumption of any parenting. What it is it's the child's right to have a good relationship with each of their parents, and the schedule for any given children have to be based on the best interest of the particular children on the particular case involving the particular parents. 50-50 schedules tend to work better when parents live relatively close together, when there's a reasonable amount of cooperation, when the kids are of school age, and they tend to work not as well with obviously infants, with teenagers who don't want that type of schedule. Once children reach a certain age, usually around 8 or 9, the United Nations Convention of the Rights of the Child make it clear that professionals need to be asking those or finding out what those children's views and preferences are, and that courts and parents and professionals need to attribute a reasonable amount of weight in light of the children's ages. So that's error number 1. Error number 2 is that once I have my 50-50 schedule, then I'm not going to pay child support. So that's not how child support works either, or that I can just not pay child support for whatever reason, right? Child support is in accordance with the guidelines. The starting point is it's with the payor's income. If the payor has the children more than 40% of the time, then the guidelines don't have to apply. However, what usually happens is a set-off. Not always, but usually a set-off. So if the kids are with the other parent, 6 out of 14 overnights or 7 out of 14 overnights, there's often a set-off. Now, where families have more money, that might mean there's just more spousal support. Why? Generally speaking, it's usually better for children to have similar lifestyles in both people's homes, right? So that's mistake number 2. Mistake number 3 is that litigants seem to think that, property also is just 50-50. It's more complicated than that. Depends if you were married, not married. Then we have trust claims, we have equalization. That's why really all clients, all possible litigants really benefit from speaking to a family lawyer, which of course is expensive. So there are some new ways people can get help through the limited scope project, where you can get a limited retainer. I founded an organization called co-founded Advice and Settlement Council, which I think is still running. So online private duty counsel, there's publicly funded duty counsel. And then in terms of the parenting stuff, the AFCC Ontario, I was on the committee that we wrote the guidelines. Those guidelines are available online for free to litigants and lawyers, and they set out the range of what are reasonable parenting time plans for kids of various ages, special needs issues, all sorts of things. So, it's really a matter of educating yourself and understanding those misnomers, so that when you have those clients come in, you can make sure you correct that. Oh yeah, here's the other big mistake. A lot of the clients want sole custody, which we don't have custody anymore. It's called major decision making, but they want that. Whatever you want to label it, that's what they want. And they don't want joint. But the reality is this: for most families, by the time they have come before the court, most of those major decisions have been made. The major decisions are education. Kids are going to go to the school where they go, or local to wherever the primary care parent is, or if the parents are in a shared parenting arrangement, whatever the closest one is to whoever, wherever it makes sense, number 1. And health, most children are going to continue to see the doctors and the dentists that they always saw. Most parents will easily agree they're likely to follow the doctor's recommendations about major issues like tonsils out. Day-to-day issues about falling out of a tree, obviously whoever has care of child, not a major issue. Religion and culture, most children have been already, raised in some sort of religion and culture, and the Supreme Court of Canada has made it clear each parent's allowed to share their respective choices with that child. And extracurricular activities, those should only be booked on the parent's time. Once you know what your parent's time is, if it's shared time like the weekends, then those should be shared. In other words, people have to agree. So those are major decisions. That's not where most people have problems. Most people have problems with day-to-day problems. Communication, they're not communicating well with the other parent. The other parent keeps, asking for changes or dropping the children off late. Day-to-day things. They don't like what the other parent's serving for dinner. That type.
Fascinating. I have a question about managing clients. I want to return to that. How does an advocate manage a client that believes that the law in the system is anti-father?
Well, I'd start with the reading material like I suggested, because the AFCCO Ontario Parenting Guide has been adopted by many judges now. It's sort of like the way, hopefully the way that the spouse support guidelines have gone, which is they're not the law, judges are not obliged, but it's a helpful tool. And as the tool is used more and more, it becomes more entrenched. And those guidelines are very, very clear that there's no favoritism between mothers or fathers, in the system. And that again, that judges are expected to be looking at every family in terms of the children's unique needs and the parents' ability to care for them. I mean, part of that does have to do with the parents' rules before the separation. Not all of it. I mean, there are sometimes disengaged parents who want to step up post-separation, and courts let them. Why? Because the children will do best according to the social science research. And that guide, by the way, is based on social science research. If they have a good relationship with each of their parents in good amounts of time. Now, sometimes family violence obviously has an impact on the schedule and an impact on decision making. So, that's a consideration that also has to be taken into account. But in terms of the courts being, anti-father, I don't agree. The judges are very well trained. We get a lot of training in all sorts of issues, including family violence, including parenting time, and I think we look at every case on its merits.
I found a fascinating section of your article, and by the way, with your permission, I will make this article available online after the interview. Again, this is the Mission Possible Responses to Difficult Client Positions article from you, Justice Himel. And one of the fascinating sections here is how do we measure success? And it's relevant to managing clients. And your definition of success, if I understand you correctly, is the result falls within the range of reasonable resolutions and meets the children's needs and interests. Is my understanding correct? Okay.
Yeah,
Can you
so
expand a little bit?
Sure. Like there's no right answer in family law cases. I mean, maybe in commercial cases it's easier. There's always a right answer and a wrong answer, and you just have to be the one who pursue. There's not. Okay. So, and I will say this to clients all the time. Okay. Your children are not going to wake up when they're 25 and say, I had a terrible childhood because I only stayed at parent A's house 5 out of 14 overnights and not 6 and not 7, only 5. I had a terrible childhood. Okay. It doesn't really matter ultimately in many cases, whether it's 5, 6, or 7. And by the way, in most cases with school-age children up through early teens, the kids will live with at least 5, 6, or 7 overnights in a 14-night period. That's the reality. So how much time and money do people really want to argue about that? That's another thing, right? But there's a range of what's reasonable. But here's what will happen. There's a good chance your kids will wake up when they're 25 and think they had a terrible childhood if every time they were late to go to one parent's home, there was an argument. If they lost their homework at the other parent's home, it was, a huge problem. It's the conflict. Children do not do well in the long term when their parents continue to be engaged in conflict. Some conflict post-separation is not that unusual, but usually by the 2-year mark, things have calmed down. But if the parents continue to engage in this all-out war, and we have case law after case law after article, that's where the children will suffer. So we just look for what's reasonable. What's reasonable? We're not looking for best day.
Do you think our law, our family law, is obsessed with separation? I'm not a family law expert, of course, but as far as I remember, separation is a condition of divorce. And I'm thinking, why can't we let people cohabitate, especially now with this real estate market? Why can't parents cohabitate? Why can't they co-parent? And why can't the system respect that? Or maybe it does, I don't know. But my impression as a relative outsider is that we are obsessed with separation. Can you talk about that a little?
Sure. There's no problem with people who want to cohabit when they are, no longer want to be in the relationship, right? There's no issue. We call that nesting. Right. So, sorry. First, we say they live separate and apart in the same house, which is often the first, especially during COVID. Lots of people were living separate and apart in the same house, usually with one parent moving to the basement or moving to some other room in the house. Okay, so and then after that, sometimes parents move on to nesting, where they actually take turns in the house and they stay somewhere else for a while. Okay? Neither of those solutions tend to be long-term solutions because of the conflict. It's very difficult once you no longer want to be married or in a relationship with someone to live in that household. As I mentioned to you, sometimes one person is the ender of the relationship. So that person emotionally has moved on during those 7 stages I talked about. One person's moved on, right? They're on, they're okay, they can co-parent, and the other parents emotionally destroyed by what's happening here. So cohabiting long-term post-separation, and also people perhaps want to date and have new partners, it tends not to work. Right? And we do see it before parenting plans are agreed to or ordered by the court, because there is this worry that if somebody leaves the home, they're going to be disadvantaged because there's going to be this status quo. So, for a long time, lawyers have advised, don't leave the house, which, may well be good advice, except of course, if there's a risk of family violence or allegations of family violence. Because as soon as there's, a complaint to the police and the police possibly lay charges, that creates a whole different problem for the person who has the charges against them. Sometimes both parties have the charges against them. And as you can imagine, post-separation, people are not only emotionally vulnerable, but financially vulnerable, right? So there's limited amounts of money. And if, people have to deal with criminal law charges, and frankly, incidences of violence are most likely to happen around the time of separation. So it's not safe for the children in some cases for people to continue to cohabit. So that's not a bad plan. It's just not a realistic plan. The nesting plan theoretically should work better, right? The parents take turns. They each stay with a friend, or some people rent an apartment. They share the apartment and then they share the house. But it still tends not to be a long-term solution.
Right. Okay. That makes a lot of sense. So another important factor is, well, probably the most important factor and the important section of your essay is children's best interests. I understand it's the paramount factor. It drives everything else. You mentioned social science research as the source of our understanding and of children's best interests, and the source of the content that we give to children's best interests. Are there any other sources of understanding of children's best interests? Is it the case law? Could it be a parent's religion? Because we can all agree that different cultures and religions can understand best interests of the children differently. And with respect to our socially accepted social science research, religion can understand children's best interests differently from the socially accepted social science research. So what are different sources of content of children's best interests, and what if there's a conflict between the socially accepted social science research and the parents' religion? What happens then?
Okay, so first of all, step one is looking at the legislation, right? So we had major Divorce Act amendments in March of 2021, which really set out the best interest test. And as you pointed out, right, there's multiple elements to that, and not one is weighted. So they're all they're all weighted, I guess, in accordance with it with any particular case. It's not the social science research that dictates the best interest. It's actually, of course, the legislation and the case law that dictates the best interest, right? And there are cases that in fact have experts. So for example, someone like Dr. Fiddler is often called upon to testify, particularly about cases about alleged alienation, parental, child resistance, and then reunification. And then from there, that cases adopt those kinds of cases, and that becomes the body of the case law. However, there is an increasing recognition that social science research is relevant and useful in family law and family law decisions, because those are professionals who are going out and researching what's best for children. But in terms of whether, let's say, religion conflicts with, some other component, I mean, it is a matter of looking at it in every case. We can't say, well, religion trumps medical. We have to look at what's the overall picture here. Yeah, here's something, right, that we always have to remember. If parents can agree, they have so much control. They can choose which of the best interests to focus on, right? But it's when they don't agree, right? That's when they need lawyers' help. a mediator's help. A mediation is very important in family law. It gives parties time to really flush out what their interests are and their needs are, and move away from their positioning and really focus on their situation, whether it's with or without children, right? Those are all things that we have to look at sort of in a more broad way in family law.
Consent and settlement are the magic wands of litigation. The same thing is true in commercial litigation. Do you think family law advocates are not pushing settlement enough? In your experience, do you think there is too much emphasis on adversity and confrontation in family law litigation? And do you think family lawyers are to blame?
No, and no. So first of all, you have to remember that most cases never come to court, right? So most parties either figure it out themselves or hire lawyers or mediators or social workers to work on the plan, and we never see those cases. So we only actually ever see the cases that are having problems. The cases that we do see, often they are high conflict. Often there has been the involvement of the Children's Aid Society, often not because of actual harm, physical harm, or whatever the other parent has alleged, sexual abuse or all this, often because of the high conflict and the emotional harm of the conflict. So we need lawyers, and good lawyers do prioritize settlement, but you don't always get settlement on day one. But the family law system, right, is designed to first and foremost deal with cases by case conferencing. So court, people come in and we talk about it, and we try to resolve things on consent. And good family lawyers know how to do that. I mean, there are a lot of unreasonable positioning. That's back to the first thing we talked about. And sometimes lawyers do, often in the court documents, unfortunately, lawyers do express, at least at the initial stages, there's clients, this is my client's position. And that does make the conflict worse when those court documents come across so aggressively. It would be better if the court documents really tried to take a less aggressive approach, but unfortunately, the actual system is still designed towards a trial, right? So when you start your pleadings, the end game is still a trial, even though, I don't know, maybe 1 to 5% of cases actually make it to trial. Most cases will settle. I think that lawyers, some lawyers are better than others about settling cases earlier on, and clients do choose the lawyers they want, right? I mean, there are lawyers who are good litigators, and clients want good litigators. They will go to them first.
So in your article, I want to jump back to social science research. In your article, you write about the utility of social science research and educational materials, and you suggest to counsel that they identify what is good versus bad research and choose well-respected publications. What is the most effective way to introduce these publications or that research into evidence? Is it by way of expert opinions that you refer to above? Or are there any other effective ways to admit this into evidence at trial?
Okay, so I would say obviously the best would be expert evidence, but most family law clients cannot afford experts, right? They're not. I mean, they can't afford experts. Realistically, what we end up with in terms of experts, right, we might have the children's lawyer do a clinical investigation, but they're not retained by one side. They're the court's assistant, basically. Or we might have the children's lawyer or someone privately do a voice of the child report, right, where they meet with the children and set out what the child's views or preferences are. Or we might have, in some cases, someone like Dr. Fiddler come. But that's where I think what courts end up making determinations about in their decisions is actually the most helpful. That's the easiest way to get the social science research in, is to be able to rely on another judge's decision who either had the expert or who had the social science research. Otherwise, I do have it argued in front of me on motion sometimes, or I have it introduced, but it doesn't have the same weight unless there's been judicial notice of it. And there is some judicial notice now of certain things. So I would say actually we're getting to the point perhaps where the AFCC Ontario Parenting Guide, where judges are increasingly taking judicial notice that is helpful, that some of the suggested parenting time schedules or decision-making ideas in there are helpful and useful, instead of requiring someone to prove all the points that's there. Because when we did the AFCC Ontario Parenting Guide, we involved a multidisciplinary group of social science people, professors, lawyers and judges, mental health professionals, and then we used the available social science research. So we didn't come up with this, right? It's all based on reliable information and people who had expertise. And again, it's intended as a guide. It's not determinative. But social science research, bringing that into court, it is a challenge. I mean, that's the reality. Obviously, courts are based on evidence.
You spoke of children's lawyer, and you spoke of this office as an amicus of sorts. But I'm trying to understand here if this is truly an amicus and has this more or less impartial role of an amicus, or is it an advocate for the child using in the same adversarial context as any advocate would be? As judges, do they view children's lawyer as one of the advocates, one of the counsel for the parties in an adversarial context, or do they have a more amicus-based view of children's lawyer?
Okay, the children's lawyer is not amicus. There has in the last few years been the use of amicus, so that's a separate entity of its own. The children's lawyer, when it is a lawyer being appointed, they do different things. When it's a lawyer being appointed in a custody and access, in the old terms, the parenting case, they are the children's advocate. They take instructions from the children and participate in a conference or a motion or a trial as the children's advocate. Now, they do more than just mimic what the children are saying. They provide the children's views and preferences in context. And what's context? It is the strength, independence, consistency, right? They don't just meet the children once, consistency, and other important factors, observations. They provide all that to the court. When cases go to trial, often the children's lawyer will by then have appointed a clinical investigator to work with the lawyer so that the lawyer has a witness, not the child, but the actual social worker who's been working with the lawyer to collect the evidence. Often they'll be giving information of third-party information. They might speak to the school and have some evidence about that. Now, that's part A. The other part of the children's lawyer is that they have clinical investigators who are usually social workers who will go out there and do a best interest investigation. It's a different section under the legislation. And in that best interest investigation, they will obviously meet with children and put their views and preferences in, but they will also, take a hard look at the child protection allegations, speak with the doctors and the teachers, and come up with a recommendation as to a parenting time plan and decision-making regime that is in the children's best interest. And then the third thing they do is they do these voice of the child reports, which are sort of quick and easy. They will go out and either by Zoom or in person, meet a child a couple of times and just be able to give to the judge maybe a 5-page report that says, this is what they said. And if they have any ability to comment on their observations, they might put that into.
This is fascinating, substantive information that I'm sure a lot of family lawyers, especially junior family lawyers, will find incredibly important. I really want to jump into trial advocacy, family law trial advocacy next. But before I do that, I want to mention another article that you sent to me. And you co-authored that article with Justice Marvin Kurtz from Milton. And it's dated May 2022. So I guess it's the latest annoyances that you experience as judges in a family court. It's called What Not to Do. And this is where I got that famous quote from: family court is not a counter at McDonald's where litigants can place their order and expect to receive whatever they please. This is great opening, almost War and Peace level, but not there yet, but it's definitely amazing. So you talk about things, a lot of things here. I'm not going to read everything, but what is interesting is that most of it is what commercial judges say to counsel. So all litigators make the same mistakes. I don't know if it's a good thing or a bad thing, probably a bad thing. So number one, procedural errors. And it's really small stuff, but probably really annoying for you. And things like single spacing, for example. So how is that affected by the digital transition that we all experienced in the last couple of years? Is it still an issue when you're reading off the screen?
Oh, it's actually way worse on the screen, right?
Yeah.
And I do print. I print various things if I want to read it more comfortably, but those issues that I raised, they're not far off of what Justice Acquarelli raised in her interview with you. I mean, the bottom line is this: we are extremely busy. Okay, so there are 2 million people who live in York Region, 2 million people accessing our court, and we have 6 full-time judges and 1 supernumerary judge. During COVID, we were really far behind, and we've actually done a great job catching up. But part of what enables us to stay caught up is the judges are working really hard, as are the staff and as are the lawyers. I don't mean it's just us. But in order to stay afloat, we need the page limits to be complied with, right? A 1-hour motion is 15 or 20 minutes for each side and a 5-minute reply. It's not 59 minutes worth of arguments, right? It's not. That's not a 1-hour motion. And we have these things stacked. So it's really important that lawyers comply with the page limits, because we need you to focus us on what we actually have to do in that available time slot and to be realistic about it. Those things are really, really important, and obviously, making sure the arguments are on point. If there's important case law, making sure you direct it to us, don't adding, excessive amounts of exhibits. The guiding idea is 10 pages of exhibits on except for certain things don't count. Don't send us 100, right? Chances are what's going to happen is the judge is going to write back and say, or tell you when you show up, I didn't read it. I didn't read it. It's not reasonable. So in my court, you get an email from my judicial assistant when the docket comes in, where I have standardized a lot of the important things about the page limits and the time limits, so that people come with their bills of cost, their offers to settle. I like to stay on top of my workload, so it's really important that everybody follow those directions.
Right. And with your permission, and I assume we have Justice Kurtz's permission as well, I will make this article also available for family law lawyers. It's really a great short piece that basically says only things that counsel should not do. I want to talk about trial advocacy. Is the proportion of cases that go to trial in family law similar to the proportion of cases that go to trial in commercial litigation, being 3 to 5%?
I think that's probably accurate. So we have in Newmarket, I think, has really changed a lot. I was a COVID judge, so I don't know what it was like before. And it was a long time since I practiced in Newmarket. But when I practiced in Newmarket, you could go up to Newmarket and wait all day and never get heard. You could be given trial dates like years and years. We don't do that anymore. So everyone's getting heard. People have their time slot. Most of it's in person, but whether it's in person or online, you're getting heard, close to your time. In terms of trials, we are moving cases to trial. People need resolution. We had about 90 cases 2 months before our trial sittings. We sit twice a year. So in November, we sat for 3 weeks. We had about 90 cases. By the time the trials came, we were down to maybe 43. We also had a whole bunch of long motions. By the time we actually heard our trials over 3 weeks, only 7 didn't get heard, from what I understand. So that's 90 cases that were supposed to go, and a few got adjourned to May. But 90 cases that were, were on the set to go, either got resolved, or they were heard, or there's a plan to deal with the remaining, few in the next few weeks. So very few cases go to trial. Most of the cases that go to trial only have 0 lawyers or 1 lawyer, or they have a client who has one or both clients who have, certain challenges that have impeded their ability to settle. For example, some clients do have mental health issues that interferes with their ability to be reasonable. And so, as a lawyer for them, there's not that much you can do other than take the case to trial. But yeah, very few cases actually go to trial, which is a good thing. We use every court date as a way to triage cases, right? Back to my road mapping, right? What's going to be the next step? In my view, in most cases, mediation is the next step. So who's going to be the mediator? When are you going to mediate? And then, is there going to be questioning before or after the mediation? Do we need to have a motion? What's the motion going to be? We're not moving motion to motion anymore. We don't have the capacity for that, and we need to share the resources with everyone, and motions are expensive. In my court, motions seem to cost about, somewhere between 5 and 8, 10,000 each side for a 1-hour motion. People can't afford that. The end result is, if litigants spend too much money on the litigation leading up to this trial, they end up being self-represented, which is back to what I said before. Most of the cases that go to trial, either one or both parties are self-represented.
So let's talk about this apparently rare situation where you are presiding over a trial where both sides are represented by counsel and both sides are represented by good, effective counsel. We all know about the general structure of a trial: opening, witnesses, closing. Can you talk about how effective lawyers structure their trials before you in more detail? So do they upload anything specific to case lines, compendiums, maybe briefs of the law or something like that? Could you talk about the structure of a trial over which you preside that makes you as a judge happy?
Okay, so we have this trial scheduling endorsement form, which usually the lawyers and the parties have come to court with 2 months before, that's where we finalize the roadmap. And we are moving towards having all trials, most of the evidence in chief go by affidavit. So that is really the lawyer's opportunity to control their case. That is a gift to the lawyers. Why? Because yes, we have page limits. Page limits, my starting point for a 5-day or 7-day trial is 20 pages, double space, font 12. Now, I'm willing to negotiate if people really think they need more, but often the lawyers are able to constrain themselves to that, and they have control over that. It also allows the lawyer, and there's timelines and all that, the chance to know the other side's case before, so they can prepare their cross-examination. Now, there's no limits on the exhibits, but good lawyering means that they don't bring in cartful and cartful of proposed exhibits, because that's what they are. They're not exhibits till I make them exhibits. They don't bring in those cartfuls. They just give me the ones that I'm likely to need. So for example, right, if at the end of the day, the exhibits for a trial are this thick, there's 2 months of Rogers bills, there's, the custody and access, or the parenting time assessment, that type of thing. Don't bring to court all 5 years of the Rogers bills. I don't need that. If I need it, I'll ask for it. When we were doing virtual trials, and most of our trials now are in person, the digital piece of it was even harder. I mean, I still like paper, so I like my exhibits to come in by paper so I can write on them and look at them and such. We don't yet have a perfect relationship with case lines in York Region. We are having some challenges with case lines, and there's a variety of reasons for that. But in terms of the good trials, I don't think case lines is going to make it or break it. The good trials come from the good advocacy, presenting your compendium, your legal argument, at the beginning of the trial, really conceding the points or settling the points where they should be settled, so that your client takes the high road, right? The issues they come to trial with are the ones that they actually think they have a claim on. Don't come to trial with 10 issues if 5 are loser. Settle the 5 and come to the trial that we really need help with. What I try to always explain to parties and remind the lawyers is a 3-day trial is much cheaper than a 5-day trial, and also easier to get, right? Because we have 3 weeks twice a year with our 6 or 7 judges, and we have to keep plotting them in. It's easier to plot them in when they're 3 days. Well, obviously, it's very challenging for lawyers if they get their trial started near the end of the sittings and it has to go over 6 months to the next sitting. So we try to avoid that, because that's not a great resolution for everyone.
You mentioned that you are moving to taking evidence in chief by affidavit. Primarily, yes. And this is, of course, like you said, it's a gift for lawyers, and I think it's a gift for parties as well. But technically, and for practical purposes, what is the effective way to introduce that? You upload that to Caseline, you upload the affidavit to Caseline, maybe make it part of the trial record, but then do you still expect an effective counsel to put the witness on the stand and maybe do a little bit of a warm-up before cross-examination?
Yeah, it's really to help the client. I mean, there's a couple things, right? So yes, let's say in a 5-day trial, the main parties will each have about 2 hours, but not nothing, 2 hours, both to update, because there might be new evidence since they swore the affidavit, also to give testimony that might be hearsay, right? So that they don't put the hearsay and the lawyers spend 3 hours arguing about what's hearsay and what's not hearsay. The good lawyers will save the possible hearsay for the oral part of it, so that they can argue about the evidentiary issue on the spot. And then also to make them feel comfortable, and so that they have a chance to tell their story. A lot of family law cases from start to finish are clients who need a chance to tell their story. So, you have your 2 hours. And then in terms of the minor witnesses, like the uncle or whoever's coming, those people only really need a chance to feel comfortable, like you pointed out. So they would be asked to adopt their affidavit. Are there any mistakes, anything they need to change? They might be asked a few warm-up questions, and after 10 or 15 minutes, off they go to cross-examination.
How do factums or arguments of law make their appearance at family trials? Do lawyers just refer verbally to the law, or do they file briefs ahead of time, or do they file briefs post factum after their closing submissions?
Well, I mean, obviously the judges have control, right? So I'm managing the case. We have single judge case management in Newmarket. So I oversee certain cases that then get given to somebody else if there's a motion, and somebody else, if there's a trial. So usually in the trial scheduling endorsement form, it says what's going to happen with those statements of law or factums or whatever you want to call those. And I mean, ideally they are delivered on the beginning of the trial. Now, sometimes they're not, in which case I just, I work with the lawyers to see what they can manage. But, I want that before the end of the trial when I'm really sitting down to start to think about. And in terms of, how it fits in, it goes into the closing argument, right? Once they've, heard all the evidence, we set out what the law is and they fit the little pieces of the puzzle into the law.
In criminal law, in criminal trials, cross-examination is the main show, I would say. And that's why criminal defense lawyers sometimes have such high profile. I think they have it because of cross-examination, not because of examination in chief. What is the role of cross-examination in family law trials?
Well, a lot of family law trials end up coming down to credibility. Right? A lot of what happened during someone's marriage or cohabitation for 10 or 15 years, people have completely different stories. So, I mean, obviously, the more evidence, the more actual factual evidence, but, attacking someone's credibility, often with documentary evidence or however, they can do that. That's an important part of cross-examination. Also, it really does help to give the judge a better idea. So when a family case starts, right, the case management judge only has a few of the puzzle pieces, right? That's how it works. And then they get to know we remember our file, we take notes on our files, people come back. So, by the end, by getting close to a trial, there's a pretty good picture. There aren't that many gaps. There's a pretty good picture. So ultimately, that picture is recreated by by the lawyers for the trial judge. And, how that picture ends up really looking depends on, in part, the cross-examination, right? What happens.
So you mentioned judges seeing pieces of the puzzle early on in the case. Is there a lot of case management in your court?
Yeah, we have single judge case management. So it's not perfect. Sometimes I'll get a case that somebody else did the last case conference, but most of the time, people will come to me for a case conference. They will come to me for a settlement conference. If I think another settlement conference is helpful, I will book an extra one. I mean, theoretically, there's only supposed to be a certain limited number, but if I think it's helpful in moving things along, I'll have them come back. If there's a motion, I won't hear a motion if I've given an opinion, because that tends to be against our idea of what's reasonable and fair. And obviously, I won't hear the trial. I will do the trial scheduling endorsement form. So that's what I was saying to you, right? I'm setting the case up for somebody else to actually hear. So I try to be as careful as I can to make sure that the case is in as good shape as it can be for somebody else.
Justice Himel, I'm not a family lawyer, but I learned so much from this interview that I will directly apply to my commercial litigation practice. So thank you so much for doing this interview. This was really a CPD. I'm going to apply to the Law Society to have this certified for professionalism hours for sure. And definitely it contains a lot of substantive content as well. Thank you, Justice Himel. I really appreciate this.
Oh, my pleasure. Thank you for having me. Have a good day.